Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides our viewers the opportunity to call in and ask me any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do call in and ask me any of your queries or questions, concerns that you have. Now, a couple of minor points before we get going. On a live show, sometimes it's difficult to take very detailed information from callers who call in. Sometimes I need to look at documents before I can advise properly. Now, if it's the case that your matter is complex or I need to look at your documents, then I will ask you to leave your number with the control room and I will have that more thorough discussion with you off air. And that discussion that we have, it's part of the free legal advice show and it's completely free of charge. So don't need to worry about any concerns regarding costs or anything of that nature. Now, two ways to get in touch. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. It's the 01924 number. And another very popular way of getting in touch is to send a message on the mobile number, which also appears at the bottom of the screen. The mobile number is just there for messages, WhatsApp messages, text messages. But to speak to me live here in the studio, please ring on that landline number, that 01924 number. Now, even before we've come on air today, we've had a number of messages coming in. So please do continue sending your messages in. So let's look at some of the questions that have come in. They look like immigration law questions, always a popular topic. Please do continue to send your questions in as always. Now the first question that's come in, let's have a look at the question. Our viewer says, hello, sir. My daughter is 6 years old, born in the United Kingdom and has refugee status until 2024. When is she eligible for indefinite leave to remain under the new rules? And that's a message from Sabah. Okay, so daughter is 6 years old, born in the United Kingdom and has refugee status until 2024. When is she eligible for indefinite leave to remain under the new rules? Now, potentially she can apply for indefinite leave to remain after 7 years in the United Kingdom. There is a test in that rule which says as long as it's not reasonable to expect you to leave the United Kingdom and you've lived in the UK for 7 years, you were born in the United Kingdom, you will be granted indefinite leave to remain. So at the age of 7, she would be eligible for indefinite leave to remain, which would take you possibly to 2023. In 2024, she would be eligible for indefinite leave to remain based on her refugee status anyway. Now, if you were to apply when she reaches the age of 7, then the only problem is that you would have to pay the full fee for that, which is in the region of £2,400. Whereas if you were to obtain indefinite leave to remain as a family and as part of the family application, she would also apply for indefinite leave to remain in 2024. If it's based on refugee status, then there would be no fee to pay. So I think the issue here really is the difference really is only going to be a year. Potentially, she can apply for indefinite leave to remain at the age of 7. To me, it looks like at the age of 8, she would be eligible for indefinite leave to remain based on her refugee status anyway. At that stage, if you were to make the application, there would be no fee to pay. If you were to rely on the 7-year rule and to apply for indefinite leave to remain, the standard fee of something in the region of a fee in the region of £2,400 would be payable. I think that's the main issue here, the cost. I think you need to balance whether it's worth going for indefinite leave to remain early and paying that extra £2,400. Now, with a lot of applications, you may be eligible for a fee waiver where you don't need to pay fees. The problem is with an indefinite leave to remain application, there is no fee waiver process that tends to apply solely to extension applications, or now they apply to nationality applications for children. It doesn't apply to ILR, indefinite leave to remain applications. So here, I think the question really is, should you go early with the ILR application, get it over and done with, or should you wait for her to complete her 5 years where you can get ILR free of charge? Hope that answers your question. Let's go to our first caller of the day. Hello, Assalamu alaikum.
Alaikum.
Walaikum salam. Ji walaikum salam. Ji bhai, thank you for calling. Ji bhai, what's your question?
Thank you for attending my call.
No problem.
I just want to ask you one question.
Yep.
I'm sponsoring my nephew from Pakistan.
Understand.
I've got all the paperwork ready, and as you advised me, I've sent them all.
Okay.
It's just that the visitor from Pakistan, there's two brothers, they're living together.
Right. There's two brothers living together. Understand.
And the house is on elder brother's wife's name.
Okay.
So I just wanted to know what sort of letter do they need to draft, because they need to send a proof of their accommodation.
Yeah. So who lives in that property? Is it just one brother who lives there? Is it both brothers?
No, both of them.
Okay. So what you could do is the sister-in-law could provide a letter and could provide proof that, look, this is our family home, which is owned by me. Here's the proof that I own the property, and I confirm that my brother-in-law also lives here, either himself or his family, and will continue to live here. He's got equal rights to live in the property, although I own the property myself. Just like a letter along those lines, or an affidavit along those lines would be fine.
Yeah, they have a 2-floor house. One is living at the bottom and the other one is living at the top.
Right, right.
So they both owners, both the house is on the big brother's wife's name.
I understand. But I think so one option is to explain that. The other option is to completely ignore that point and don't include any evidence in relation to ownership of the accommodation, but include other evidence, so employment income, other assets that he may own, to include evidence of that. And if he has family there, evidence of family. So you leave this point, but you address the other points that you need to address.
Right, he can provide his earnings and his personal details, but does he not have to provide proof or anything like that for his accommodation?
If he doesn't own it, my personal view is that if he doesn't own the property, I wouldn't say anything about ownership of the property. I wouldn't say anything on that. I'd just leave that.
Oh, just leave it.
I wouldn't address that point.
Right.
Because my concern is, if we were to say the sister-in-law owns it, the downside to that approach is they might turn around and say, but you don't even own the property that you live in. That's my only concern. I would not address that point at all and concentrate on other stronger points in the application.
That's fine. Yeah. Thanks very much for your advice.
No problem. Jazakallah, brother. Thank you very much.
Thank you very much.
For your call. Thank you very much. Thank you. Now, as always, visitor applications is always a popular topic on the show. Okay, let's look at the next question that's come in. Slightly different question to our normal immigration law questions. It's a family law related topic. Let's have a look at that. Our viewer says, I married under Islamic law in the United Kingdom 10 years ago. Now I have difficulty to prove this in court. I don't have any financial rights. How can I prove this? Now, I'm not entirely sure what your specific concern is, but if your question is, how can I prove that I am Islamically married? I think the question really is, how significant that is. Because if you are only married under Islamic law in the United Kingdom, then unfortunately, in terms of finances, you would have limited rights if your marriage is simply an Islamic marriage. So let me give an example. If both parties are married under Islamic law and the other party, so let's say the husband under Islamic law is the one who's purchased the house that you live in, and he's the one who's paying the mortgage and all the capital expenditure in relation to the house, maybe an extension, etc. He's making all those payments. The difficulty in that scenario is that the normal rights that a wife has upon divorce in terms of a share in the marital home wouldn't normally apply where the marriage was simply an Islamic marriage. Certainly it would be more difficult to prove a right in that property. Now, there are ways around it, but it is more difficult. If you have contributed towards the mortgage, or if you could establish that there was some understanding between the parties that even though the property is in that person's name, it's a joint property. If you've spent money in terms of an extension to the house, etc., then you might be able to establish a beneficial ownership in the house. But you do have an uphill struggle because the normal rights which arise simply because the parties were married and they are now divorcing, the normal rights in relation to a share in the marital property and indeed other assets doesn't arise that easily. There are additional steps you would have to take in order to demonstrate that you have a right, a financial right to the property. That's the difficulty. So we can look at this matter and the other questions in greater detail. We'll be back in a few minutes. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, to send us a message with your questions, you can do that on the mobile number which is also there at the bottom of the screen. If you are simply trying to prove that you are Islamically married, then that could be done by getting evidence from the person who conducted the marriage, other parties who may be aware that you are married, and indeed proof that you've been living together over a considerable period of time. I think all those factors would point towards there being an Islamic marriage at the very least. So if you couldn't produce the Islamic marriage certificate, there is additional evidence, other evidence, I should say, you can get to establish your Islamic marriage. But the problem is, I don't think that gets you very far because normally the rights that arise would arise from being married, having a marriage which is recognized by English law. And I think that's where the difficulty is. An Islamic marriage in the UK generally would not be recognized under English law. There are exceptions. You could have the marriage could have taken place where a marriage is accepted because it's a registered place for registered marriages, but it's highly unlikely in most cases for that to apply. If a marriage simply takes place in a mosque or takes place at home, it's unlikely that the marriage would be recognized as a legal marriage. Now, the other way you might have a share in the property is if you have children from the relationship, from the Islamic marriage, who live with you, then based on the children, there might be a share in the property. So in answer to your question, how do you prove the Islamic marriage has taken place? If you can't find the certificate, the way it's proven is through evidence of witnesses. But I think the question is wider than that, or the issue is wider than that, is even by proving that you were Islamically married, does it really make a difference? Or is there another way that you can establish your financial rights following the breakdown of the relationship, whether it's because of the children that you may have, whether it's because of an agreement that you have between yourselves, whether it's because you've paid the mortgage or you've made you paid for certain expenses in relation to the property. So there may be other ways in which you can establish your right in the property, even if you were only married under Islamic law and not married in a way that is recognized by the UK courts. So hope that answers the question. If I haven't answered your specific question, please do get in touch. Thank you very much for that. Okay, another few questions coming in. Next question is, looks like a contractual dispute. If someone has given me a promissory note for money owed, how do I go about enforcing this? Would I need to issue court proceedings? Now, this is applicable to this situation. Generally speaking, if you are owed money which is not paid, the way you would go about it is there's two options. First of all, normally this is what happens. You issue proceedings in the county court. If the claim is for less than £10,000, it will go into the small claims court. If it's higher than £10,000, it will be dealt with under the fast track. If it's a bigger case, it will be dealt with under the multi-track. But the claim would normally be issued in the county court. You can go online and you can do this now online. There would be a fee payable. You would have to explain what your claim is. So normally what you would do is issue proceedings in the county court. The other option that you have, this may or may not work, is to start the process which allows you to go for bankruptcy of that individual. So you could serve a statutory demand on that person saying, this is the money that you owe me. Now, if there is no defense to it and the person doesn't pay, you could commence bankruptcy proceedings of that. The amount of money that is payable, from my recollection, has to be at least £750 before you can go down that process. So the normal process for enforcing or trying to get money back which is owed to you is to go down the county court route. You can try stat demand as well, where it's absolutely clear cut that the money is owed. The person isn't going to raise a defense. He's not going to say, I paid you, or it was only payable under these circumstances and they haven't arisen yet. So if it's clear cut, there's no defense to it, you might be able to start the process for bankruptcy, which is started by issuing a statutory demand. So they're the two options: county court proceedings or serving a statutory demand and proceeding with bankruptcy. That applies to any money which is owed to you. But thank you very much for that question. Okay. Next question that's come in. We've had a couple of immigration law questions coming in. Fantastic. Please do continue to send your questions in. And as always, you can ring on the landline number and speak to me live on air as well. Okay. Next question that's come in is, brother says, Assalamu alaikum. I would like to know if I can apply for a spouse visa without giving my dad's passport details on the application form. My dad has applied for a new passport and it's been 4 months. Is there a way around this? So you're saying, can I apply for a spouse visa without giving my dad's passport details? Now, if you're the applicant applying for the spouse visa, so you're the person wanting to come to the United Kingdom, and you're the person applying for a spouse visa from outside the United Kingdom, then they will ask you for your mum and dad's name and date of birth. You don't need to provide the passport details. So you don't need to provide the passport number. You don't need to provide issue and expiry date. On the application form, you can skip those parts. An out-of-country spouse application, if that's what you're making, you will only have to provide your mother and father's name and date of birth. You don't have to provide passport details or issue and expiry dates for the passport. You can skip those questions. Now, if you're in the United Kingdom at the moment and you are maybe switching into a spouse visa, so you could be here as a student and you've got married to somebody who's a British citizen or has indefinite leave to remain, and now you want to apply for a spouse visa within the United Kingdom. If that's the case, then they won't ask for your mother and father's name and date of birth either. So there's nothing that you need to provide in terms of your parents for an in-country partner application or an extension. So this issue only arises if you are the applicant, not your spouse, if you are the applicant applying from abroad to come to the United Kingdom. It's only in that case that the applicant's mother and father's name and date of birth have to be provided. Thank you very much for that question. If you're not sure, please do get back in touch. I know you've said here you're waiting for mum and dad's passport to be issued. There's no reason to wait any longer. If you're ready to make the application, if your other requirements are met, please do go ahead and apply. Okay. Now, next question that's come in regarding somebody who has Chinese residency. So I'm assuming they're not a Chinese national, but they have some kind of leave to remain or permanent residence in China. How can they move to permanent residence in the United Kingdom? That's quite a wide-ranging question. They would first of all have to move to the UK. And there are various routes under which you can move to the UK, which leads to settlement. Some routes won't lead to settlement, such as if you come on a student visa, it won't lead to settlement. But what you would have to do is coming to the UK on a route which leads to indefinite leave to remain. It could be a spouse visa, it could be a work permit, it could be a startup visa, innovator visa. So there are certain visa routes that you would need to come to the UK under, and that would then lead to indefinite leave to remain. You can't just apply to come here on permanent basis, just like that. Let's look at the next question which has come in, which is about problems traveling abroad. And it's a question that's been sent in by Brother Nasser. Quite a long question, but I've had a look at this over the break. Let's look at the question together and see what practical advice that I can give on this. Brother Nasser says, I am 54 years old, a British citizen living in Coventry. I just renewed my British passport. Previous passport was still valid, but I was growing old and my facial expression appearance had changed. Okay. Now, I got it renewed with a new photo. Fair enough. After that, I recently visited the United States, and I was interviewed there by an immigration officer at JFK Airport. Followed by Canada. In Canada, I was interviewed again. These interviews were about an hour and a half long, with all kind of questions, which was very worrying. I believe that when they renewed my passport, they put some kind of indicator which alerts immigration staff in any country. If my assumption is correct, is there anything I can do legally to remove such a marker from my passport? I'm seeking your advice so I can have a better travel experience and not be interviewed for hours on end. Thank you for your help and guidance. Now, that's very unfortunate indeed. Now, in my experience, there's two things. One is, if there's a problem that occurs here in the United Kingdom, it's slightly more easier to resolve, and you can get in touch with the Home Office, you can get your MP involved, etc. They can make representations to the Home Office, and you can try and clear things up slightly more easily so that you don't get a problem when you're coming back into the UK on your British passport. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, you can continue to send your questions in on the mobile number which also appears at the bottom of the screen. So the landline number to speak to me live on air, and the mobile number for questions that you want answered, which you can send in on text or WhatsApp. So along that line, if it's a problem with entry into the UK, and there is sometimes a problem regarding that, you can try and address that. Now, the problem is, first of all, why is it that this has occurred in America? Whether it's you've been interviewed by immigration officers from US and Canada in America, whether you've then flown to Canada and you've been stopped there. Why is it? Now, normally, in my experience, the reason that this seems to happen is that you have a similar name to somebody else who is on a list which is of interest to these authorities. So when you're traveling and your name is similar to the name of somebody else who's of interest, it would be flagged up. Now, the problem is a lot of people have similar names, and that's why you do get flagged up when there's no reason for you to be a person of interest to them at all. But it's normally because your name is similar to the name of somebody else that they're interested in. The problem is this problem won't necessarily go away. All that could happen is that next time round, when you go there and if you're stopped again, you can say, look, you know what, this happened to me on this date. If you check your records, you'll find that I was interviewed and cleared. There's obviously some kind of crossover with another name, and that's why an alert is being triggered. Now, it's unlikely, what you suggest, brother, is that when the passport was renewed in the UK, there might have been some marker placed on your passport. It's unlikely that that's the case. I think what's more likely is your name is on a list which is of interest, a list of names which is of interest to them, and it just seems to be similar to that other person who they're interested in. I think that's the most likely scenario here. I think it would be difficult to try and address that from here in terms of trying to get the US authorities to remove any marker which is on your file. I think all you can practically do is say to them, look, I've been through this before. Clearly there's a mix-up. You know, if you check your records, you'll find that I'm really not of interest to you. I think the likelihood is that that's the case. Anything else that you could do realistically, I think it's going to be very difficult. In my experience, when people have written to authorities, they've just come back and said, well, we take note of what you say, but we do take security issues very seriously. And, you know, if immigration staff feel that they do need to speak to people who are flying in, then obviously they will make their appropriate inquiries. They're not very helpful. They don't seem to do anything to remove any markers on your passport, unfortunately. So my view is practically all you can do is to say to them that, look, I've been through this before. If you check your records, you'll find that, you know, you've got the wrong person, effectively. But hope that goes some way towards answering your question. Jazakallah, thank you very much for that call. Okay, now, got a number of other questions coming in. Let's look at that. Now, the next question that's coming is, our viewer says, Assalamu alaikum, my son married a girl who is deaf and mute. My son is also deaf and mute. How can they pass the English A1 as they only use sign language? Now, if obviously A1 English test is a spoken test, it's a speaking and listening test, what you can do is apply for an exemption from the A1 test. So when the girl, the daughter-in-law, is applying from abroad, you would fulfill all the other requirements. In terms of English, you would state that you are applying for an exemption and you would provide medical evidence in relation to that. And in terms of medical evidence, it would simply be a doctor's letter confirming the illness and that you wouldn't be able to sit the A1 test in English. So that's the way it would have to be done. That it's because of the disability, it's not possible to sit the A1 test in English. And on that basis, your daughter-in-law should be exempt from the English language requirement. I hope that answers your question. Thank you for that. Okay. Now, let's look at the next question that's come in. Immigration law question. A viewer says, hi, I am a British citizen. My mum, who is a widow, has been travelling to the UK for the last 15 years on a visit visa. Okay. Currently, she holds a 10-year visit visa, but now her health has deteriorated and she can't travel alone. Is there any way to get her permanent residency here in the United Kingdom? I live with my wife and children here in the UK. This is a very common question that arises as to how you can get permanent residence for your children, for your parents, mom, dad, who live abroad. And now it's fantastic that at least mother has a visitor visa, so she is able to travel. Now, that's all well and good. There's a 10-year visit visa here, so she can come and go as she wants. If she was to apply for the adult dependent relative visa from abroad, it would be very, very difficult to get a visa. Most of these applications are refused. They tend to say, we're not prepared to grant an adult dependent relative visa because there are care facilities in your home country, and they refuse it on that basis. So I wouldn't recommend an adult dependent relative visa. Now, if your mom, for example, was to travel here and then her health gets worse, for example, and then you decide, look, she can't really travel back, I would then suggest trying for a human rights type application from here, an application outside the rules for her to be allowed to stay here. So if she was to travel here, for example, her health gets worse, she can't travel back, you could try a human rights type application from here. Now, you need a bit of luck. Home Office tends to refuse those applications. They tend to go to an appeal, and it really boils down to whether the judge is prepared to grant leave to remain under human rights laws or not. Some judges do, some don't. Very difficult to judge how things would pan out. In my experience, it really does depend on the kind of judge that you've got. With a sympathetic judge, you could get this application through. But no, I don't think a lawyer can guarantee that this kind of application would be successful. So my suggestion would be that if she was to come here, if, for example, her health was to get worse, you would then look at a human rights type application from the United Kingdom. And if the application was successful, that wouldn't lead to indefinite leave to remain. She would get a 2.5-year visa, which you could continue to extend in the United Kingdom. I hope that helps. Thank you very much for that question. Okay, now let's look at the next question. Our viewer says, Assalamu alaikum, I would like to apply for a spouse visa for my daughter's fiance. Okay. What's the best way of doing it? My daughter is earning around £25,000 a year. My son-in-law studied at Warwickshire University. Okay, now I'm assuming that son-in-law has now gone back. So he studied at Warwickshire University. Obviously, if he's still here, you can make an in-country, they can get married at a registry office. You can make an in-country application for his visa to be extended. Now, if he's abroad, and I think he's abroad, because you're talking about a spouse visa, fairly straightforward. You can either make a fiancé application, or if your daughter can go abroad and register the marriage, you can make a normal spouse application. Based on the income of £25,000 a year, the income is more than sufficient. You only need an income of £18,600 a year. So on finances, there's no problem. If daughter's earning this money, finances is fine. The only issue is, should it be a fiancé application, or should they register the marriage and make a spouse application? Fiancé application can succeed. You will need to show that they have photos together to show that they've met. My personal preference is, if you can go abroad, register the marriage, that's always easier in the long run. You get your spouse visa straight away. But I can't see any problems here. The income is fine as well. From my perspective, I think what I would say is that you need to decide whether you want to go down the fiancé route, where he comes on a fiancé visa, you register the marriage here, and then you transfer to a partner visa, or do you just go abroad, get the marriage done, and the son-in-law comes as a partner with a normal spouse visa? I think that's really the issue. Finances is not an issue here at all. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please ring on the landline number which appears at the bottom of the screen. As always, please do continue to send your questions in on that mobile number which is also there at the bottom of the screen. We've still got a number of questions that have come in on the mobile number to get through. But as always, please do continue to call us on the landline number as well, which is there, the 01924 number. Okay, let's look at some of the other questions that have come in. Question is, my sister's husband has applied for his British passport without her signature. They are separated. How did he get his British passport? Now, for the British passport application, the partner's signature, the partner's consent isn't required. So normally when somebody comes to the United Kingdom on a spouse visa, whether it's the initial application to come to the UK, the extension, or the application for indefinite leave to remain, at all stages, because it's a visa normally based on your spouse, because it's a partner visa, all the way through that process, the partner's consent, the partner's signature is required. So there'll be a form that the partner signs. Normally, it's like a declaration saying that you're together, etc. It doesn't apply when you make a British passport application. So it doesn't apply at that stage, unfortunately for you. That application for citizenship can be made immediately after you get indefinite leave to remain if you're married to somebody British, or you can simply wait 1 year and make the application in your own right. But there is no need for the partner's signature. Thank you very much for that call. Let's go to our next call. Hello, assalamu alaikum.
Assalamu alaikum. My name is Tahir. I called earlier, I think a few weeks ago.
Right.
Basically asked question, but I think you have not too much time to explain my answer.
Okay.
Basically, I want to know, I'm on the 10-year route parent, parent base, and so before now in next month I will finish 5 years.
Okay.
So I want to switch to 10-year route to 5-year route,
Okay.
because earlier I applied for 5-year route, but they put me on that 10-year route.
Okay.
So kindly tell me in detail what should I do.
So you're on the parent route, yeah, not the partner route. Parent. Which route are you under?
Yeah, I'm parents route. Yeah.
Yeah, not partner.
I apply on the basis of my son, my kids. Yeah.
Okay, so you're in terms of your partner or ex-partner, what's the situation there?
We are separated. Yeah.
That's why. Sorry, I assumed that was the case, but I just wanted to clarify that. And do you have contact with the children, or do the children live with you?
Sorry, I can't hear you.
Do the children live with you, or do you have contact?
No, they live with mom.
That's fine. So you have contact. Yeah? Okay. When did you come to the UK?
Sorry?
When did you come to the UK?
I came UK in 2014.
14.
But before that, 2017, I'm on the different visa as a carer. So in 2017, I apply on the basis of my son.
Okay.
And
so 2014, you came to the UK. Did you overstay?
2014, yes.
Yeah. Did you overstay at any stage? Did you overstay?
No, never.
Never overstayed. Yeah.
Sorry?
You have never overstayed.
No, because the first time they gave me a visa and then they refused me next time as a carer, and then in the meantime, in that 28 days I apply for the basis of my son.
Okay.
So I'm never overstay.
Okay, that's fine, right? So you can apply for. When did you come to the UK in 2014? Which month did you come in?
In November.
Okay, so you can potentially apply in October 2024 anyway for indefinite leave to remain.
Yeah.
So in just over 2 years' time, you can apply for indefinite leave to remain based on 10 years legal residence.
But my visa finishing next month, so
okay.
I'm applying now. So can you advise me regarding that? If I apply now, so
if you apply now, if you want to go in to the 5-year route, there are two things you need to do. Two things. One is English, right?
Yeah, I got a certificate B1. Yeah.
When did you get it?
This month.
Fantastic. First thing done. Secondly is your income. Your income doesn't have to be 18,600, but it has to be enough to pay for your expenses, right? So what is your rent and council tax payments? How much?
No, basically I'm living with my mom, so everything is on mom name.
Fine. Okay. Now, how much do you earn a month or a week, however you get paid?
Yeah, basically I'm start working permanently in the May.
Okay.
I got permanent job, but before that I'm working with this company from March.
Okay.
So if I check my last 6 months gross pay, I crossed that one, but net pay I didn't cross.
No, it's fine. It's fine. No, you don't need to show 18,600. The 18,600 rule doesn't apply to you.
Okay.
It doesn't apply to somebody applying under the 5-year parent route. It only applies to partner route.
Fine.
So you just need an income of 100, not even £100 a week. It's about £80 a week. Is your 80, £85 a week is how much you need in your pocket. That's all you need.
Sorry, sir, can I watch TV and you tell me again?
Yeah, that's fine. That's fine. No problem.
It's not working properly, so I can't understand.
No problem. No problem.
If you repeat for me, please. Thank you very much.
Okay, thank you. Thank you very much. Okay,
thank you for your time. Thank you.
Okay. So just for the benefit of our brother who wasn't able to hear properly, I think he must have been very close to the TV, and sometimes it's very difficult to hear the answers that have been given. Now, so what I'm saying is, if you're applying under the 5-year parent route, not the partner route, you need to show English and you need to show enough money to live on. If you're a single person with no living accommodation expenses, you only need an income of about £85 a week in your pocket. And that is sufficient for you to apply under the 5-year parent route. But thank you very much for that call. We've got another caller that's waiting. Let's go to our next caller. Hello, assalamu alaikum. Hello, assalamu alaikum.
Hello.
Hello, assalamu alaikum. Hello, brother. You're live on air. I can hear you.
Can you hear me?
I can hear you, yeah. Fire away.
Okay, brother, my question is that my father passed away in December,
Okay.
and my father has some money in his bank account in Pakistan.
Okay.
And we want to convert that into my mother's name.
I understand.
And we wanted to know if you can tell me the procedure.
The only way you can do it is normally you would get a power of attorney done.
Power of attorney.
Yeah. So because the problem is this isn't really, here in the UK you do something called probate, which allows dad's property to be dealt with by mother, etc. There's a separate process for probate here. That doesn't apply abroad. That only applies in relation to UK property. So in terms of property abroad, you'll have to follow the procedure there. But normally what people will do is appoint somebody to deal with the transfer, and you do a power of attorney from here. So your mum would be given a power to, let's say, a relative to sort these things out.
So us 7 brothers, we are 7 brothers and sisters, and we want to give the power of attorney to our mother because my mother's going to go to Pakistan.
Yeah,
and it's not possible for us 7 brothers and sisters to go to Pakistan at the same time.
That's fine. But
so when we go to the Pakistan consulate in this country, we basically have to, because on the consulate website there's there's an example of a power of attorney. So us 7 brothers and sisters have to fill that in. But what about if all 7 brothers can't make it to the consulate?
Right, but there's 2 things. Okay, if you have NADRA cards, you would normally go to the consulate. If you don't have a NADRA card, then you can sign the document before a solicitor and you send it to the legalization office.
Okay.
So there's 2 different ways of doing it. Normally, if you have a NADRA card on the power of attorney, you put your NADRA details, you have to then go to the consulate. If not, you can ignore that process. If there's no NADRA card, you sign it before a solicitor, the solicitor sends it to the legalization office, and you use that. So you're going to have to do 2 separate documents for the ones that get it done at the consulate, the ones that get it signed before a solicitor and it's sent to the legalization office. In terms of drawing the power of attorney up, you're probably better off just speaking to an immigration lawyer because they're used to the format and stuff, so they'll get it all ready for you. But the way round the NADRA office is to get a solicitor to, for it to be signed before a solicitor and for it to be sent to the legalization office. Pakistan, they'll accept that as well. They'll accept both.
All of us brothers and sisters have got another card. The only issue we have is actually all of us having to go to the consulate. Do we all have to go to the consulate?
You do, because they won't accept the signature before a solicitor. They won't accept it. I think this is a problem now. You'd all have to go. I mean, the only way around it would be you can do individual ones, so people go whenever they're free. But if you're going to get it done in one document, you would all have to go together. It's just because of safety measures that Pakistan has this procedure. They won't accept a solicitor's signature.
Okay, thank you very much.
Okay, brother. Thank you, Jazakallah. Thank you very much for your call. Thank you. But thank you, brother. Thank you very much for that call. We have a number of questions. Let me run through one more question before we get to the end. A viewer asking, how long does it take for a spouse visa nowadays? Applied for our daughter's husband to come to the UK about 2 months ago. We haven't heard anything. Unfortunately, at the moment, it's taking around 24 weeks from the date the passport is handed in for a decision. So it's 24 weeks from the date the passport is handed in for a decision. So it is taking a long time, just under 6 months from the date the passport is handed in that you are likely to get a decision. Why is it taking so long? Well, the Home Office is saying that they've redeployed staff into the team that's dealing with Ukrainian visas, and that's created a backlog, and that's why it's taking much longer than before. There is no fast track. They're not turning it around in 3 months. Realistically, we're looking at 24 weeks, 6 months for a decision. So you will get a decision, inshallah, positive, but you will have to wait a little longer to get that decision. Unfortunately, that brings us to the end of the show. Inshallah, we'll be back next week. See you then. Assalamu alaikum.